Okay, so you're here because you want to get to the bottom of things, right? Complex topics. Without, getting lost in the weeds. You want to cut to the chase, be in the know.
That's exactly it.
Today, we're going deep on a legal case, Amec Capital Projects Limited v. Whitefriars City Estates Limited. That's from 2004, EWCA Civ 1418.
Big one.
It might sound intimidating, but honestly, there's so much to learn here about how these construction contracts work, the role of adjudicators, and what happens when things get a bit sticky.
Fairness, yeah. Big questions about fairness.
Exactly. We're talking about Amec versus Whitefriars City Estates. We'll break down the key events, the legal arguments, and that big decision for the Court of Appeal. So by the end, you'll really get why this case matters.
It's a case with some wider implications, too, even though it's about a specific construction contract. I mean, the ideas it touches on, like how disputes should be resolved and making sure the decision maker is totally impartial.
Yeah, so what were our sources for this deep dive?
We've got the full judgment from the Court of Appeal, which is pretty detailed, and we've also got a helpful summary that pulls out the main points. We're basically doing the heavy lifting for you. You get the core insights without needing a law degree.
Perfect. So let's go back to the beginning. What started all of this between Amec, and Whitefriars? What is that core issue they were fighting about?
Right, so it all starts with a contract. Whitefriars brings in Amec to do some initial work, pre-construction stuff, and then manage procurement for the next stage of this building project.
Well,
They're using a standard form contract from the JCT, the Joint Contracts Tribunal, which is super common in the UK for construction. But they've made some tweaks, some amendments. What's key here is that they've got a mechanism for resolving disputes, adjudication.
okay.
It's designed to be fast, get things sorted quickly. The problem is, Whitefriars decides to terminate the contract, but Amec has already done some work.
Oh.
Amec thinks, hold on, we're owed money here, unpaid invoices.
Yeah.
That's where the conflict kicks off.
Unpaid invoices. A tale as old as time. So Amec, if they try to sort this out, right, what happens with that first adjudication attempt?
So they go for it. They approach RIBA, the Royal Institute of British Architects, to appoint an adjudicator, and RIBA appoints a Mr. Michael Biscoe.
Okay.
He's working under what's called the Scheme for Construction Contracts. Think of it like a set of default rules for adjudication if a contract doesn't have its own clear process or if things go sideways with that process.
Wait.
Whitefriars, though. They challenge this appointment in court. Judge Humphrey Lloyd QC ends up ruling that Mr. Biscoe, he actually didn't have the authority, the jurisdiction, to make a decision in that first round.
Jurisdiction. That's a big word here.
Yeah.
So basically, did the adjudicator even have the right to be involved at all?
Yeah, exactly. It's about whether he had the legal power to make a decision that would stick.
So why did the judge say Mr. Biscoe didn't have that authority?
It all comes down to how the contract was worded, specifically that adjudication clause. They named a George Ashworth of Davis, Langdon, and Everest as the adjudicator, or someone he nominated if he couldn't do it. Turns out it was supposed to be Jeffrey Ashworth, also from Davis, Langdon, and Everest. A little bit of a mix-up.
Oh.
Judge Lloyd said Amec should have tried to follow that contract process first, go to Jeffrey Ashworth or whoever he nominated. Because they went straight to RIBA under the scheme, Mr. Biscoe's appointment was basically a no-go. The first adjudication, it just fizzled out because they didn't follow those initial rules in the contract.
So the first round, a technical knockout. But they don't give up, right? Amec goes for round two. What's the thinking behind this second attempt?
That's right, persistence. They start a second adjudication, same claim. Those unpaid invoices, their argument this time. That contract mechanism for appointing an adjudicator, it's totally failed now. Why?
Oh.
Sadly, Jeffrey Ashworth had passed away. He's no longer around. So Amec, they say, okay, now the scheme for construction contracts, that kicks in. They're entitled to go to RIBA. They do just that. RIBA says, okay, Mr. Biscoe, you're back in.
Round two for Mr. Biscoe. Same dispute, new adjudication. Does he stick with his original decision, the one from the first round that technically didn't count?
He does. Mr. Biscoe issues another decision, still siding with Amec, but just like the first time, Whitefriars isn't budging. They're not paying up. They resist this second decision. And their objections, they've got two now. First, the jurisdiction thing, again, they're saying Mr. Biscoe still has no authority. And second, they're making a pretty serious claim, saying there was a breach of natural justice. Basically, they're accusing Mr. Biscoe of bias.
This is where it gets juicy. Accusations of bias. Always interesting. But before we jump into that, let's clear up this jurisdiction issue in the second adjudication. Why did Whitefriars still think Mr. Biscoe couldn't make the call?
Okay, so They're saying even though Jeffrey Ashworth has passed away, the contract still has a way to appoint an adjudicator without going to the scheme. They point to Clause 39A.3.2 in the contract. They interpret it like this. If the named adjudicator is unavailable, which they argue Jeffrey Ashworth is because he's passed away, then Amec should have gone to the partner or director managing his practice at Davis Langdon and Everest to get a replacement. Because they went back to Reba, Whitefriars is saying, nope, Mr. Biscoe, still no authority.
But the Court of Appeal, they didn't buy that, right? What was their logic? What's the takeaway here?
Exactly. They agreed with Judge Tolman QC, who'd made the initial decision. Lord Justice Dyson, he was the main judge on this, said that Clause 79A.2 is all about that initial appointment of the adjudicator. It lists all the different ways that appointment could happen in the first place. But get this, Jeffrey Ashworth was unavailable before any initial appointment could happen under that clause.
Right.
Clause 39A.3 is different. That kicks in after an adjudicator has been appointed, and then something happens and they can't continue. The timing is key.
So simply put, if the named adjudicator can't do it from the start, that initial appointment process is a bust and you can turn to the scheme. But if they're appointed and then they become unavailable, you stick with the contract's replacement rules.
Spot on. The court thought Whitefriars' interpretation of that phrase referred to him in Clause 39A.3 was a bit of a stretch, trying to make it fit when a referral never actually happened because Mr. Ashworth wasn't there. The court said, look, there might be other complications with how you read these clauses, but what matters is how it was supposed to work in practice. And because that initial process couldn't happen because of Mr. Ashworth passing away, the scheme was the right way to go for the second adjudication.
Okay, so we've got jurisdiction settled for round 2. Now let's talk about that elephant in the room, those bias allegations against Mr. Biscoe. Before we go into the specifics, can you remind us what are the fundamental principles of natural justice here?
Sure. Natural justice is all about making sure decisions are made fairly. 2 main things. 1, anyone who might be affected by a decision, they have a right to know what's going on, the case against them, and a chance to tell their side of the story.
Fair enough.
2, the decision makers, they've got to be impartial, unbiased. In this case, Whitefriars wasn't saying they didn't get to present their side. Their whole focus was on that second principle. They're claiming Mr. Biscoe just wasn't impartial.
And they're calling it apparent bias. What does that actually mean for this case?
Okay, so the test for apparent bias is this. Would a fair-minded, informed person, knowing all the facts, think there's a real possibility the decision-maker, Mr. Biscoe, was biased? This comes from a famous case, Porter v. McGill. The point is, you don't have to prove the decision-maker was actually biased, just that a reasonable person might have a genuine concern about their impartiality.
Interesting. So what were Whitefriars' arguments? Why did they think a reasonable person would be concerned about Mr. Biscoe's impartiality in that second adjudication?
They had a few. First, they said, look, Mr. Biscoe's already ruled on this exact same claim in the first adjudication, even though that was later thrown out because of jurisdiction.
Right.
Second, they claim legal advice Mr. Biscoe got during that first invalid adjudication, advice neither Amec nor Whitefriars knew about at the time, somehow tainted his thinking in the second one.
Okay.
Third, there was this phone call between Amec's solicitor and Mr. Biscoe after he's reappointed. Then there's the legal advice Mr. Biscoe got during the second adjudication, specifically about whether he even had jurisdiction and when he told the parties about it. Finally, they argue, because Whitefriars spent a lot of money fighting that first flawed adjudication, and they might try to get those costs back from Mr. Biscoe personally, that creates a conflict of interest.
Okay, lots to unpack. So let's go through each of those arguments one by one and see how the Court of Appeal responded. First, the fact that Mr. Biscoe already ruled on the same issue. Did the court see that as proof of bias?
No, they were clear about that. They basically said just because a decision maker, whether it's a judge or an adjudicator, has decided something similar or even the same before, doesn't mean they're going to be biased the next time. Judges and adjudicators are supposed to be professionals. They can approach each case with an open mind, even if they've seen similar stuff before.
Makes sense. What about the argument that the legal advice from that first adjudication, the one that didn't count, somehow messed up the second one?
The court wasn't convinced by that either. They looked at what that advice was actually about. It focused on a clause about giving written notice if someone wasn't going to pay.
Right.
But in the second adjudication, Whitefriars' main argument had shifted to a different part of the contract. This time, it was about how the contract ended. Because that initial advice didn't even touch on the main issue in round 2, the court said it just wasn't relevant, couldn't have led to bias.
Let's talk about that phone call now between Amec's solicitor and Mr. Biscoe. What happened there, and why did Whitefriars think it was a problem?
Right. So after Mr. Biscoe is reappointed, Amec's solicitor, a Mr. Cassidy, he calls Mr. Biscoe's office. He mainly wants to know where to send the documents. But during the call, he mentions that Amec wanted Mr. Biscoe specifically because he already knew about the case. He figures this will save time and money.
I see.
Whitefriars thought this was an attempt to influence Mr. Biscoe, like he was being told to reach the same conclusion as before just because he had already seen the case.
So did the Court of Appeal agree that this phone call was evidence of bias?
Nope, not at all. They looked at Mr. Biscoe's notes from the call and agreed that it was mostly about admin stuff. They said, even if Mr. Cassidy hadn't said it outright, it's pretty obvious why they wanted Mr. Biscoe again, because he already knew the issues, especially after that court ruling about jurisdiction. The court didn't think this comment was telling Mr. Biscoe to decide a certain way, or that a reasonable person would think Mr. Biscoe was just going to rubber stamp his first decision. They did say, ideally, you want to avoid these kinds of direct conversations, just one party with the adjudicator, to keep things transparent, but they didn't think there was anything in this particular call that suggested bias.
All right, what about the legal advice Mr. Biscoe got during the second adjudication? The one about whether he even had jurisdiction? Whitefriars wasn't upset that he got advice, right? It was about when he told them about it.
You got it. Mr. Biscoe did get legal advice, just to be sure he could actually act in the second adjudication. He was told, yes, his appointment by RIBA was valid. Then he let both Amec and Whitefriars know about the advice and what it said, but he only did that after he'd already decided he had jurisdiction. Whitefriars said he should have told them about it before he made that decision, so they could have responded to that advice, made their own arguments. Actually, Judge Tolman QC in the lower court, he agreed with Whitefriars on this point. He thought it was a breach of natural justice.
But the Court of Appeal, they didn't see it that way.
Right. They disagreed with Judge Tolman on that point. They said when an adjudicator decides about their own jurisdiction, it's not legally binding on the parties until a court looks at it.
Oh, yeah.
It's different from deciding about the actual dispute. It doesn't directly affect the parties' rights and obligations in the same way. So they said those strict rules of natural justice, like having a chance to speak up before a decision is made, they don't necessarily apply strongly to jurisdiction decisions. They did say it's good practice to let the parties comment on jurisdiction issues if there's time, but they didn't think this specific situation was a breach of natural justice or showed bias.
So there's a subtle difference in how natural justice applies, depending on whether the decision is about jurisdiction or the actual substance of the dispute. Okay, last one. Whitefriars argued that because they might sue Mr. Biscoe to get back the money they spent on that first adjudication, the one that was invalid, that he might be biased against them.
The Court of Appeals shut that down pretty quickly. They said the scheme for construction contracts, it has rules to protect adjudicators. They can't be held liable for stuff they do or don't do as an adjudicator unless they acted in bad faith. And no one was accusing Mr. Biscoe of that.
Right.
So basically, Whitefriars had almost no chance of winning a case against him. The court even said if just the threat of being sued could mean bias, that would be a really easy way for parties to manipulate the whole adjudication process.
So all things considered, the Court of Appeal ultimately took Amec's side.
Yeah.
What was their final decision?
Yeah, they sided with Amec. They said no evidence of bias from Mr. Biscoe, and they agreed with the lower court that he did have the authority to make that second decision. So Whitefriars had to pay Amec the money from the adjudication, plus interest and all those legal fees.
So for our listeners who are with us on this deep dive, what are the big takeaways from this Amec v. Whitefriars case?
There are a few. First, it really clarifies how you should read those adjudication clauses in contracts. That difference between the first appointment and replacing an adjudicator is huge. Second, it shows how hard it is to prove apparent bias. Courts aren't just going to believe vague accusations. Third, if an adjudicator has already ruled on the same dispute, even if that first ruling didn't count, it doesn't automatically mean bias in the next round.
Okay.
Then there's the communication thing. Talking directly to the adjudicator when the other party isn't there, not ideal, but it doesn't automatically equal bias, especially if it's just admin stuff and not trying to sway the decision. Also, natural justice. Those rules, they apply differently depending on whether the decision is about jurisdiction or the heart of the dispute. And threatening to sue an adjudicator, bad idea. courts won't see that as evidence of bias.
So it sounds like the courts are really behind this adjudication process. They see it as a fast, efficient way to resolve disputes.
Absolutely.
They're not going to overturn decisions lightly. So for our listeners, here's something to think about. The court kept saying how important it is to consider the fair-minded and informed observer. What do you think really matters when deciding if someone might be biased? It's about more than just this case. It's about fairness, impartiality, and trust in how we resolve disputes.
Great question.
If you want to learn more, you can find the full judgment and other resources online. But for now, thanks for diving deep with us.